This is Bloomberg Law with June Grasso from Bloomberg Radio.
In an unprecedented and stunning decision, the Colorado Supreme Court has barred Donald Trump from the state's March 5th primary ballot. By a narrow vote, the court found that the former president's actions inciting the January 6th attack on the U.S. Capitol make him ineligible to run again under Section 3 of the 14th Amendment. That's a post-Civil War era provision of the Constitution that bans insurrectionists from holding public office. It's a little surprising that some of Trump's rivals for the Republican presidential nomination, like Chris Christie and Nikki Haley, denounced the decision.
I do not believe Donald Trump should be prevented from being president of the United States by any court. I think he should be prevented from being president of the United States by the voters of this country.
So I want to see this in the hands of the voters. We're going to win this the right way. We're going to do what we need to do. But the last thing we want is judges telling us who can and can't be on the ballot.
Trump's campaign immediately said it would appeal the decision to the U.S. Supreme Court. Joining me is Harold Krent, a professor at the Chicago-Kent College of Law. Is there any precedent at all for this ruling?
There's no direct precedent for the Colorado Supreme Court ruling, and this issue has raised so many complicated constitutional issues that really only the U.S. Supreme Court can resolve the challenge once and for all.
Let's start with the text of the 14th Amendment doesn't actually define an insurrection or spell out what it means to engage in insurrection. Yet the court upheld the trial judge's conclusion that the January 6th assault was an insurrection, that Trump engaged in that insurrection. Is that a big jump for the court?
I think the jump is more about who gets to make the call as to whether President Trump engaged in insurrection or not. I mean, the definition of insurrection has to be balanced with free speech rights, and the question is whether President Trump was just using rhetoric to rally the troops, or was he actively engaging in inciting imminent violence. And obviously the Colorado court, not based upon a hearing, but based upon largely upon the transcript of the January 6th congressional investigation, held that President Trump's talk went over the line to actually incite imminent violence and not just to speak more generally about the importance of being vigilant and showing your voice. In my view, I think the Colorado Supreme Court had a very persuasive decision on that ground, that there was, in fact, more than just talk, but rather the talk was inextricably linked with imminent action on that day to stop the electors from certifying Joe Biden as the next president. But the real question in my mind is who makes that call? Is this to be made after a trial? Is this to be made after an evidentiary hearing? And we don't know, and that's the thicket that the Colorado Supreme Court has entered into.
The lower court, who decided that there was an insurrection and that Trump engaged in that insurrection, there was a week-long trial about that, right?
So there was a week-long trial. It wasn't with cross-examination, but there was evidence of information that was presented. So it was a kind of mini-trial. And, one of the other background issues in this case is in Colorado law, as in other states, not all, there's an ability to have an expedited challenge to somebody who's on the ballot as being inappropriate. And, of course, that's the context in which this arose. The Republican voters decided that the Secretary of State should not allow President Trump on the ballot because he wasn't qualified. And the issue in most cases, you're not qualified because of residential qualifications, you haven't been there long enough, because your age is wrong, you're under 35, so forth and so on. And it's easy in an expedited decision just to make those kinds of judgments to decide whether someone should stay on the ballot. In this case, though, it's so complicated because the question of whether there was an insurrection and whether President Trump incited the insurrection, stuff can't be decided under these kind of streamlined treatment. So again, it raises the question of whether both did Colorado intend this, and should this be the way that we decide whether someone does engage in insurrection. So the quick, abbreviated 5-day hearing was largely based upon January 6th committee's notes, and those were comprehensive. But in a normal state of things, we won't have that kind of record to rely upon, which raises the question again, is should the court in this expedited proceeding be the entity to determine whether a candidate has engaged in an insurrection?
Section 3 doesn't mention the presidency, and the Colorado justices broke from the trial judge on this one key issue, which makes the difference. They reversed her decision that the insurrection ban applies to every office except the presidency. Where do you stand on that?
Yeah, I mean, I think that the Colorado Supreme Court was on very strong ground in rejecting the trial court's decision that all other officers of the United States are covered by the insurrection clause except for the president. To be sure, the president is not named explicitly, but the president is an officer in the United States in common parlance. The president does take an oath to uphold the Constitution like other officers. And indeed, one of the principal reasons for the 14th Amendment was to prevent people like Jefferson Davis, who was the president of the Confederacy, from ever being able to hold office again. And under the trial court's reasoning, Jefferson Davis could have run for president. And that just seems to be so far afield from what the framers of the 14th Amendment thought that I think it's on very weak ground. So I think on this particular issue, the Colorado Supreme Court had the far stronger decision.
All 7 justices were appointed by Democratic governors. It was a 4-3 ruling, and the 3 justices who dissented did so on procedural grounds, and they each presented a different legal argument in their opinions. Do the dissents offer a sort of framework for arguments that Trump can make to try to overturn the ruling?
The arguments were connected in this sense. The question really focused in different language on whether a challenge to a ballot listing is the proper procedure to determine whether someone engaged in insurrection. Viewed at the most sort of global level, the question is whether Amendment 14 is self-executing. And by that we mean, can any voter trigger a question as to authorization or qualification under the 14th Amendment, or rather does Congress have to set a procedure out in which the question of insurrection and qualification can be measured? So, for instance, in 1870, the Congress did pass an Insurrection Act under which district attorneys of the United States could go to court to challenge the ability of a former Confederate officer to serve a federal office. That was repealed in 1948, and so the question would be whether we have to await another congressional sort of decision as to how to enforce the terms of Amendment 14, Section 3. And that's a very fraught issue, which has obviously never been clearly determined one way or the other, because there is a kind of logic to the sense that we should wait for Congress to tell us how to enforce this provision, as opposed to just individual voters triggering a election board to make this very complicated decision based upon almost no precedence whatsoever. I should also add that Congress does have a criminal provision which provides for disqualification from office as well for aiding insurrection, but that, of course, is replete with all the protections of a criminal trial, and Jack Smith, the special counsel, has not charged President Trump under this section. Rather, he's chosen other provisions to charge him with. So we do have a process now, implicitly, in order to determine whether someone's engaged in insurrection and therefore disqualified, but that has not been pursued. And so the major question, I think, lurking under all of this is whether, again, under different formats, whether this Colorado election challenge is the appropriate vehicle for determining whether or not a insurrection indeed took place, which would lead to the disqualification of the candidate.
Coming up next, echoes of the controversial Bush v. Gore decision. I'm June Grasso, and you're listening to Bloomberg. I've been talking to Professor Harold Krent of the Chicago-Kent College of Law about the Colorado Supreme Court barring Donald Trump from the state's March 5th primary ballot in an unprecedented ruling. The Colorado Chief Justice, in a dissenting opinion, said the ruling was premature because Trump hasn't been criminally convicted of insurrection, but he hasn't even been charged with insurrection. So there are factual determinations to be made as well as legal determinations.
Right. I mean, I think that's, to me, there's one other issue that the Colorado justices mentioned, but I think the overarching issue is who should make this decision as to whether President Trump engaged in insurrection and under what circumstances. And it's at least odd, if not inconsistent with the Constitution, to say that this incredibly important decision is made on an expedited basis without a jury and without many of the safeguards of a criminal trial. Now, if indeed the framers of the amendment thought that was appropriate, so be it. But you have to have, I think, in my mind, pretty clear evidence that that's what the framers had in mind, rather than this sort of expedited hearing that took place in this case. The other issue that was raised in dissent was one of due process, that this is not a full and fair trial, and the former president did not have those kind of procedural protections before being thrown off the ballot. I don't think that argument is going to hold up at all. I think the real issue is not one of protecting former President Trump, but one of protecting the electorate. And so I think to the extent that the dissenting justice made this point in the case, the real argument should be substituted is we want to make sure we have a very careful process before we deny the will of the people. And so to the extent that there were concerns about this truncated process, that would go to making sure we have full and adequate protection for the electorate, not for the individual who is seeking office. But altogether, I think it's a very close case, not because of whether or not President Trump engaged in insurrection, and there was no dissenting justice on that point, but rather on the question, is this the forum, is this the time to make the determination in each of the states as to whether Trump engaged in insurrection, because obviously that's just going to lead to a different result in different states and would undermine really the ability, I think, to have a fair and impartial process to proceed upon to determine whether former President Trump should indeed be on the ballot for the primary, which is starting at least in Colorado, in early March.
Trump's campaign immediately said that it would appeal the decision to the Supreme Court, the U.S. Supreme Court. That's no surprise. Even, the Colorado court anticipated that. Is this a case that the justices almost have to take?
I think so. I think the Colorado court knew that this was important, that their decision was going to lock in the decisions of other states, because even if some states said no and some states said yes, effectively former President Trump would be off the ballot in enough states as to change the election result and throw the election into turmoil. So the court recognized that, and I think the U.S. Supreme Court is really, their hand is forced. I think they have to take this case and have some kind of expedited decision as to who should make the call as to whether or not the candidate has engaged in insurrection and therefore is not qualified under the ballot. Now, clearly, whether a candidate has residency requirements, whether a candidate is 35 or not, those kinds of issues can be determined quite easily by a state election board. But on the question of insurrection, I think maybe we need a different process in the absence of Congress, and the court will determine, is there a process absent a congressional structure? And if so, what that process will be for determining whether or not the candidate engaged in insurrection after taking an oath as an officer of the United States.
Doesn't the Supreme Court usually have to accept the facts of the case below? And here, both the lower court and the Colorado Supreme Court said he did engage in an insurrection.
Yeah, I don't think they will look at the facts of the case to determine whether or not what the standard is under Brandenburg versus Ohio or something in terms of what is incitement. I think rather what the court will do is simply try to figure out who has the right to make that determination. And the issue is whether, in part, whether 14th Amendment in this respect is self-executing, or whether or not Congress has to create the procedure, and the only procedure that it's created so far is a trial, and disqualification will follow on the heels of a successful trial.
The Supreme Court, as we've discussed, has a conservative supermajority with 3 justices appointed by Trump. Is there anything you can conclude from that lineup that tells you about how they'll approach the case?
My guess is they won't touch the question of whether President Trump engaged in insurrection. They have, of course, questions of the presidential immunity that is before the court right now. But rather what they will do, and I would guess if I had to, is that they will decide that whatever the proper procedure is to determine whether someone engaged in insurrection, that this process is wanting and therefore cannot stand. But, of course, at the same time, they will be forced to make a call as to what the proper process would be and whether or not it's up to Congress to set the guidelines for any kind of inquiry that would be disqualification.
This puts the 2024 presidential election basically in the hands of the Supreme Court again, like Bush v. Gore, which remains one of the most controversial decisions in U.S. history. And the country right now is more politically divided than it was then.
Absolutely. And how this plays out politically overall is a critical issue. Will this embolden supporters of Trump to think that former President Trump is not getting a fair shake? Will they come out in droves to support him? And will this pressure the U.S. Supreme Court to make a decision on behalf of former President Trump? Again, I don't think the issues are clear-cut, and I do think that the court may try to find a middle ground by saying that the analysis was partially correct by the Colorado Supreme Court, but the inquiry that led to that decision is simply the inappropriate inquiry to kick somebody off the presidential ballot. I think they will say that the law, the Constitution applies to ex-President Trump, but that to determine whether he engaged in insurrection, at the minimum, you need to have a full evidentiary hearing, and perhaps even more than that, you need to have a criminal trial. The U.S. Supreme Court really could try to do a down-the-middle type of decision by being empathetic to the Colorado Supreme Court, but yet holding that this is not the kind of process that was envisioned by the framers of the 14th Amendment. But we'll see.
The conservatives on the court are textualists. So do you think they'll analyze this by looking at the language of the 14th Amendment?
The language in this case is simply not clear. No one can say for certain that the language forces a particular outcome. The court will be grappling with the history of the 14th Amendment. That has to be center of any kind of analysis, and we know the issue that the Congress faced was what to do about all of those Confederate officers to make sure they didn't resume positions of authority, and this clause was aimed at preventing that. And the question is how the court can make sense of that without agreeing with the Colorado Supreme Court. And I think, again, the way they can try to put those two competing sort of vectors together is by saying, absolutely, that's what Congress intended through the 14th Amendment, but it's failed after repealing the 1870 Insurrection Act of giving another procedure that is adequate to make that inquiry possible. And so if I had to guess now, that's what I would think the U.S. Supreme Court would say.
Is this a case where Clarence Thomas should recuse himself because his wife was at the ellipse, etc.?
Well, that's obviously a tough question. He hasn't shown much interest in recusing himself previously. And, of course, it's not a question of whether the insurrectionists engaged in insurrection. It's whether President Trump did, which is analytically distinct. But, yes, I think that in an other world, Justice Thomas would recuse himself, but my guess is he won't in this case.
Thanks, Hal. That's Harold Krent of Chicago-Kent College of Law. Coming up next, a new Texas law makes illegal immigration a state crime. I'm June Grasso, and you're listening to Bloomberg.
This is Bloomberg Law with June Grasso from Bloomberg Radio.
Senate Bill 4 is now law in the state of Texas.
Senate Bill 4 allows police in Texas to arrest migrants who illegally cross into the country and empowers local judges to order them to leave the country. On Monday, Republican Governor Greg Abbott signed the bill into law.
The goal of Senate Bill 4 is to stop the tidal wave of illegal entry into Texas. It creates a criminal offense for illegal entry into Texas from a foreign nation.
The law challenges the federal government's exclusive enforcement of immigration laws. Less than 24 hours after the signing, civil rights groups in Texas's largest border county filed a lawsuit, calling the measure an unconstitutional reach over the U.S. government's authority on immigration. Joining me is immigration law expert Leon Fresco, a partner at Holland Knight. Tell us about the law, Leon, and what it does.
Well, the law does two things. So the first one, which is not controversial, devotes more money toward border security, and that's permitted, and nobody thinks that that isn't in terms of border security, resources for their officers, et cetera. There is some question about some border barriers, that the money is funding to see whether those border barriers are going to be deployed in an unconstitutional manner. But that's one aspect. The more controversial aspect is 3 new state law offenses that are created by the statute. One is illegal entry from a foreign nation. The second is illegal reentry. And third is refusal to comply with an order to return to the foreign nation. And so here's how basically this is going to work. Texas will now have the authority to have its officers arrest people that it thinks have illegally crossed from Mexico into the United States. Now, what's interesting is the law doesn't require a visual in order to arrest the person. So it could be that the person was here a week or two, and then this is where that's going to get complicated, is it's almost certain they're going to get some of those wrong if they actually make arrests like that. But let's say they only limit the arrest to people they visually see entering illegally. The next step is those people can be arrested and charged for a misdemeanor. And the way it will work is they will go into a court hearing where the judge will say, look, you don't have to have this criminal conviction, but what you have to agree to do is to go back to Mexico, and then we'll just call it even and there won't be any conviction. If the person refuses to do that, then the person will be charged and placed in prison for up to 6 months under this Texas offense. And then what Texas actually says is if they refuse to comply with a condition that says after this release they have to go back into Mexico, then they can actually be rearrested and charged with a felony that would put them in prison for up to 20 years. And so this raises a whole bunch of questions, such as what happens if the person's asking for asylum and they just get ensnared in this web in Texas? Would they actually have to leave the country and lose their asylum claim, or would they be able to have some sort of way through this without having to potentially face 20 years in prison? And that is pretty much the most egregious unresolved aspect of the Texas law. But the main sort of complaint is that we have gone through this before with Arizona doing something very similar, and at the end of the day, the Arizona law being stricken down as being an illegal state law encroachment into federal immigration enforcement.
Crossing between ports of entry is already a crime under federal law, isn't it? Aren't federal agents supposed to be arresting migrants for that?
Absolutely. Crossing the border illegally is a criminal offense under federal law. It's a misdemeanor. The problem is the federal government does not have anywhere near the resources it needs to prosecute every single person who did this. We're on pace currently to have something like 3.6 million unlawful border crossings in 2023, 2024. And what that would mean is you'd have to have prison space, prison beds, to put those people into custody, and there's nothing like that. So what the federal government does is it only prosecutes people who are either criminals who have re-entered the United States or people who are doing some other dangerous thing like drug smuggling or something else while they're crossing the border. But just a simple first-time border crosser very rarely gets prosecuted at the moment for unlawful entry in between the ports of entry.
Couldn't the border agents turn them around and send them back across the border?
So this depends. Under Title 42, that was happening systematically, which was pretty much any person who entered unlawfully through the ports of entry was being pushed back into Mexico. Now, there isn't a law or a regulation that requires this. Certainly, the federal agents can volunteer this offer and say, look, we're going to put you in CBP detention, then we're going to put you in ICE detention. Do you really want this? Wouldn't you prefer to just go back into Mexico? And sometimes people do take that, what's called voluntary return option, back into Mexico. But more often than not, people instead ask for asylum and wait whatever time they have to wait temporarily in custody to get processed through that so that they can enter the United States while their asylum case is pending.
Didn't Homeland Security Secretary Alejandro Mayorkas say that people who arrive at the border without using a lawful pathway will be presumed ineligible for asylum?
That's correct, but here is how that works. So just because you are banned from getting asylum doesn't mean you're banned from getting something called withholding of removal. So what happens is asylum is a discretionary form of relief that the federal government gives by statute that it doesn't have to give, which gives people a path to citizenship and the ability to earn a green card. They get the ability to bring family over. But that's not the only way to basically save yourself. You can get this second status called withholding of removal, which means you get to stay in the U.S., but you get no other such rights like a green card, citizenship, ability to bring family, or any of that. And what happens is even though there's a ban on receiving asylum for people, there isn't a ban on receiving withholding of removal. So people, if they meet a slightly higher threshold for articulating a claim, which is called a reasonable fear standard, as opposed to the credible fear standard, which is the lower standard used for asylum cases. If you can meet a slightly higher standard called the reasonable fear standard, then you are permitted to stay, even if you cross in between the port of entry, and even if you will not be able to get asylum, you're still allowed to stay to make your withholding of removal case in the immigration court.
Civil rights organizations sued less than 24 hours after Abbott signed the law. They're challenging the constitutionality of it, and they cite that Supreme Court case in 2012 in Arizona.
Correct. The ACLU sued in the Western District of Texas in Austin, and they are suing on behalf of certain immigrants' rights groups and also on behalf of El Paso County. And they're suing the state of Texas, public officials, saying that at the end of the day, they need injunctive relief from this SB4 in Texas because this is the exact same scenario as Arizona, that a state cannot criminalize being unlawfully present because that is a federal immigration enforcement prerogative, and it is not something that the state of Texas can do. The state of Texas is preempted by federal law from doing it. Now, just to give you some composition of how this works, it is expected that there will be three justices, the liberal three, Sotomayor, Jackson, and Kagan, who will be sympathetic to such a claim. And Justice Roberts also voted on the side of the federal government and against Arizona in the Arizona case. There will be two justices, Alito and Thomas, who voted on the side of Arizona during the Arizona case. And so what we do not know is what about the remaining three new ones, Kavanaugh, Gorsuch, and Amy Coney Barrett? Are they going to side with the state of Texas and overturn the Arizona case and say that states can indeed do prosecutions if they're literally prosecuting the exact same thing that the federal government is prosecuting and not something different? Or will they rule to keep the Arizona precedent and say that this cannot be done and we're not going to overturn that precedent? And so we will see. There's good arguments on both sides of this. Certainly the federal government prosecutes drug offenses, as does state governments. So both do that. But by the same token, states don't prosecute things such as failing to file your federal tax return. That's done only by the federal government. And so we're going to see where along the line does immigration fall within those spectrums.
This law doesn't go into effect until March, I think it is. So if the district court doesn't grant an injunction, then this might go into effect before the Supreme Court has a chance to hear it?
If the district court in Austin enjoins SB4, then I think you'll see a very slow path of this case to get all the way to the Supreme Court, and I don't think it will take a very short route. If, however, the court in Texas says this is legal and Texas actually starts enforcing the law, you will see an immediate request for a stay in the Fifth Circuit, which if the district court doesn't enjoin it, it's very likely neither would the Fifth Circuit. And then you'd see an immediate request for a stay in the Supreme Court. So probably within 30 days, you would see some sort of decision by the Supreme Court whether to stay this law or not, pending review. So that would happen quickly, but I don't think it would happen quickly in the alternative side, where if the district court in Texas or the Fifth Circuit were to say that this is indeed preempted and it's illegal, I think you would see this work its way up slowly through the courts.
When Abbott signed this, there were signs that read in English and Spanish, "Warning, it's illegal to cross here, punishable by removal or imprisonment." And he called the legislation so extreme that it would drive migrants away from Texas. So that just means they'll cross into other states, right? And Arizona already is so overwhelmed that the governor deployed the National Guard to help.
Yes, there's basically two places where you can cross. It's Texas and Arizona, because the California border with Mexico is pretty much all triple fence. It's a very small border, as is the New Mexico border is a very small border, which is basically triple fenced as well. And so really the only places that are open are in Arizona and in Texas. And if people say that they are experiencing these arrests in Texas, then certainly you will see people move to Arizona, and it'll be unclear if Arizona will pass a law similar to Texas, because, of course, Arizona has to deal with the Ninth Circuit, and Texas gets to deal with the Fifth Circuit. So that changes dramatically. There'd almost be no reason for Arizona to think that they could pass a law that would be in any way allowed to be enforced. So they'd have to wait to see what the Supreme Court says before they could go ahead and pass a law on their end.
There's also a question, it seems, about whether Texas can process all these people if they do make arrests, because some border sheriffs have expressed concerns that this would overwhelm the local jails and courts.
That's correct. The purpose of this law would not actually be to arrest the border crossers coming into Texas in sort of a massive scale. It would be just to create fear that you could be one of the people that gets stuck in this Texas web, and so don't come into Texas. And I think what they would try to do is create enough examples to scare enough people to try to move people out from Texas and into other locations. And that would be their goal. But you're correct to say that if the actual goal was to arrest every person coming into Texas, and there wasn't a reduction based off of fear, there was no way they could do it. Texas would have no way to actually arrest and detain 1 million people or 1.5 million people coming into Texas. But what they could do is, if they get enough stories out there of just terrible circumstances faced by people that entered Texas, their ideal scenario would be that people stopped entering because they heard of these terrible scenarios.
Thanks so much, Leon. And you'll be back tomorrow when we'll talk about the record numbers of migrants who are crossing the southern border illegally and the Senate negotiations over border policy. Thanks so much. That's Leon Fresco, a partner at Holland Knight. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.